From a policy perspective, Amendment 62 would create a legal quagmire. This amendment would impact literally thousands of laws, creating ambiguities in almost every area of law, and clogging our courts with litigation over such issues as property rights and inheritance matters. The word person appears over 20,000 times in the Colorado statutes. It also appears thousands of times in state regulations and municipal ordinances. Amendment 62 would effectively amend every statute, regulation, and ordinance that contains this term. Our scarce judicial resources should not be wasted attempting to interpret and enforce Amendment 62 at the state and local levels. Furthermore, Amendment 62 would affect personal private decisions of women and their families, many of these with legal impacts. I'm now going to introduce Andrew Toft from the Colorado Bar Association, who will further explain why Amendment 62 is bad law.
Thank you. Good afternoon. The Colorado Bar Association is joining the Colorado Women's Bar Association today in opposing Amendment 62 because of the ramifications the amendment would have on the interpretation and application of Colorado statutes, ordinances, regulations, and case law. Legislators and judges will be required to look at literally thousands of laws through a new set of lenses. The change represents a serious departure from well-established definitions in our statutes and regulations. This is much more complex than it appears on the surface. Almost every area of law would be impacted, including criminal law, family law, trusts and estates, real estate law, elder law, tort law, juvenile law, health law, and business law. It's my pleasure to now introduce the next speaker, who is Kevin Paul, counsel for Planned Parenthood and counsel for the No on 62 campaign.
Thank you, Andrew. Well, as Andrew stated, I'm here today in my capacity as General Counsel to Planned Parenthood of the Rocky Mountains, a position I've held for about 15 years now. And in that time, I've seen over and over and over again efforts to restrict and limit individual decision-making with respect to reproductive choice. And I feel like I should start by saying, well, here we go again. Here we go again in particular because there's no principled way to distinguish between Amendment 62 and Amendment 48, which of course you'll remember that just 2 years ago, an overwhelming majority of Colorado voters rejected soundly in the general election in November of 2008. The fact that the word that was used in Amendment 48, the phrase, from the moment of fertilization, has now been changed to the beginning of biological development, makes no difference to me as a lawyer, and I would hazard to say that it makes no difference to my colleagues from the CBA and the CWBA, who I thank for taking the position that they are today. It doesn't answer any of the myriad questions that Amendment 62 lays open. And in fact, probably the most important problem with Amendment 62, as has been pointed out, is that while it affects a broad sweep of our Colorado law, the answer that everyone gives to the question, what will it do, is I don't know. No one is willing to hazard a guess what this change to our Constitution will actually, what kind of a result it will actually have for our criminal law, our children's code, tort law, wills, trusts, estates, contract law, as has been pointed out. We don't know what this will do. And that strikes me as a very ill-advised basis for making changes to fundamental rights that are enshrined in our Constitution. It is certainly not the case, as the proponents have argued, that there's some sort of gap in our law, that Amendment 62 is necessary in order to fill. The definition of person, particularly for purposes of federal law, was long ago resolved. In Roe v. Wade, the state of Texas argued that one of the reasons it should be able to outlaw abortion is that a fetus is a person for purposes of the same kinds of constitutional protections that Amendment 62 seeks to address. And the U.S. Supreme Court said, no, that is not the case. Roe v. Wade resolved this. It has never been questioned in subsequent federal decisions, and for Colorado to adopt Amendment 62 would fly in the face of that established constitutional precedent. Finally, I would point out that there's no legitimate public policy purpose for which Amendment 62 is necessary. Whether you want to talk about in vitro fertilization or stem cell research, reproductive rights or assaults or homicides that are perpetrated against pregnant women, our legislative process, a deliberative process where we actually sit down and figure out what the results of a particular statute are going to be is more than satisfactory in order to deal with any of these problems that are raised. Amendment 62 simply isn't necessary unless you have one public policy purpose, and that is to prohibit abortion, emergency contraception, and most forms of birth control, which is exactly what the proponents have said they're attempting to do. That's an illegitimate purpose. It's one that Planned Parenthood opposes, and I greatly thank my colleagues from the Colorado Bar Association and the Colorado Women's Bar Association for taking a strong position in opposition to this amendment. I'll now ask Lucy to take the podium again and answer any questions.